All right, Dad, guilty across the board very quickly, less than 3 hours. Let's start with the verdict and then we'll work backwards and talk about closing arguments. Were you surprised at the guilty verdict?
I was not surprised at the guilty verdict for the M.
Okay.
I was surprised by the guilty verdict for the sandwich. That one did surprise me, especially considering how short the deliberations were. I just can't believe somebody on that jury didn't think it was a ridiculous guilty to find guilty of the attempted M on the sandwich. It boggles my mind, but I was not surprised by the M guilty verdict. I think we even said it before, that even though we would not, and we saw a lot of reasonable doubt, we can certainly see that a jury could find her guilty.
Yeah, but I think that you can't really be that surprised once they were guilty. I get that if we would have taken each individual one with the evidence presented, there were a lot more issues with all of the other charges versus the count one, the aggravated M. But anytime you see a case like this where the other charges, you can call them lesser charges, you can call them attached charges, when they have to do with the same exact form or conduct or substance as the first charge, it's almost always guilty. Where there's a financial piece to it and they have a fraud charge or an insurance fraud charge or a forgery charge. We've had cases like that. They almost always, if they're going to convict on one, they convict on all of them. And that's kind of what they did with the attempted M. They put it together and was like, this is how she does it. You have the same MO. You talk to the drug dealer, you get the drugs, you put it in his food, he gets sick, you asked for more, you put more in his drink, and then he dies. Because you wanted the Michael Jackson stuff, you needed something stronger. So it's not that shot. I mean, I get it based on the evidence. It is probably the least evidence I've ever seen a conviction of an attempted M charge in my life. What about you? Have you ever seen less evidence than this get a conviction?
Never. And I tell you what usually happens, and I know what you're saying, and I agree that happens a lot, but also what happens a lot is jurors are back there and you'll get, half the jury saying, guilty on everything, and then you get half the jury that's got some kind of a problem. And the way you deal with that half of the jury with some kind of a problem is you give them a bone. And the bone is, okay, we'll do a not guilty on the sandwich. Is that okay? And they go, okay, yeah, all right, then fine, not guilty on the sandwich. So they kind of split the baby. And that's what happens a lot in these kind of verdicts. And that's why you do get split. Plus, myself, I like to see these kind of different verdicts, not like guilty across the board, because it shows me that the jurors really deliberated and really looked at each charge individually, like the judge tells them to do, and make a decision on each charge individually based on the evidence just on that charge. Yeah. So that's what I like to see.
Yeah, no, and we'll get to the timing of the verdict, but so in 50 years, prosecuting cases, state and federal level, and defending cases for 40 of those 50 years, never seen less evidence get a conviction on attempted M before.
Never.
Yeah. I mean,
absolutely.
13 years, much less than you. Not even close. Like I would never bring this charge if I was a prosecutor,
Never.
But
never. I would never approve this.
But you understand why they did to help prove the aggravated M. That's why they did it. They wanted to show this MO. If they didn't have that other charge, it would have cut out a bunch of evidence as being irrelevant potentially, or they maybe have argued that it was, she tried to do it the first time, but not enough to actually bring a charge. You can still argue it as unindicted criminal acts or whatever, prior bad acts. You could bring it in under a prior bad act, things like that.
Well, the important thing for them, again, talking about just this case and how they presented it, they had Carmen on there, and they had Carmen's history of selling her these drugs. Plus, they've got the drug dealer, Robbie, and his history of providing the drugs. So if you're going through the history and going through the timeline, the Valentine's Day fits into their timeline. So it really is something that was easy for them to smoothly present as part of their timeline, and it would have made it a little bit jerky if they hadn't charged, the sandwich.
Yeah. And I also agree with you and think that the prosecutors may have been worried or considering a split baby verdict because that's why they brought all these charges. They gave the jurors multiple opportunities to throw out one that wouldn't have mattered as long as they convicted on, count one and then a couple other ones. So it did work out for the prosecutors. And you said you were going to be kind of bent up if this is all it took to get a guilty conviction or a guilty verdict. I kind of felt like she did do it, even though I did think the evidence was lackings, especially on the other 4 counts. And I said, maybe I could be convinced in the jury room of count 1, but I would have walked in there probably thinking not guilty. But you did not feel the same way. So how do you feel now that it's a guilty verdict?
Well, I still think it was a pretty weak case for M, but it is an impossible case to. I mean, again, that attempted murder was just. We considered in about 2 seconds go through the evidence they had of that attempted M, and the sandwich. I mean, come on, the guy felt sick. Come on, went to work the next day. Of course, we know the prosecutor had, he's a tough guy. He was a cowboy. But, the fact is, they had no evidence that there was anything in that sandwich and no evidence that he suffered any ill effects because of what was in that sandwich. That, I'll be honest with you, if I was the judge, I probably would have given a directed verdict on the sandwich.
I agree. And people are going to be like, oh, that's crazy. But it's like, go in there and just try that one count. Good luck. Because that's how it should be.
Yeah.
That's how you should have to try a case to convict on a count of attempted M. You should have enough evidence where if it was the only thing you were going in there and trying the case on, that you would be able to win. And there's just no way. There's no way. I want to talk to some other people about that too. And I think I will as we go forward, but because it was very different than the actual M charge. Like they had so much more on the M charge than they did on the attempt charge, like what was in his stomach. That fentanyl actually made its way into his stomach, but we don't need to go round and round about that. So, but as it comes to the actual count 1 M charge, the aggravated M charge, what are your thoughts on that? I know you're not surprised, but do you think that it's, an injustice or anything like that based on the evidence that was presented?
Well, I think it was an injustice, and I know we'll get to the closing arguments, but I think that one of the key thoughts that a juror should have been put into a juror's mind is, if, let's say, and we know obviously this can't happen, that Eric comes back to life, and there's a knock at the back of the courtroom door, and he opens the courtroom door, he walks in and he says, gee, I'm really sorry, but I accidentally took those pills, and that's what happened. Did the prosecution prove that Eric was lying? Did they prove beyond a reasonable doubt that Eric could not have taken those by accident? And if Eric came in and said he took it by accident, is the jury making a huge mistake here? Did that possibility really exist that he could have taken them accidentally? And did the prosecution prove he didn't take them accidentally?
Yeah, I think you could do that in a lot of cases. I think you could do that in a lot of cases, and I think that there's a reason we can't argue that.
Well, you can. Yes, you can.
That's really.
That's not a. Oh, there's nothing wrong with that argument.
I've never
There's
heard
nothing
it before.
wrong with that
I've never
argument.
heard it before because, listen, if it's a reasonable alternative like the defense argued and it can be a reasonable doubt, then fine. But I think that you can do that in a lot of cases to say that, if they came back to life and told you this was the truth, how would you know it's not the truth? And you're saying the jury needs to be able to answer that question. Because
it has to be to the exclusion of every reasonable doubt.
Yeah. So you're saying that the jury has to have the evidence to answer that question. I guess that is fair. That's a fair argument. That's a fair argument.
Yeah. And so did the jury have enough to exclude him saying, if he walked in here tomorrow and said it was an accidental overdose, did they have enough evidence to exclude that as a reasonable possibility? I don't think they did.
And so their answer would be, yes, we did, because we know Kouri wanted to kill Eric because she told her friend she'd be better off if she was dead. She'd be set for life if he was no longer with us. She tried to change the insurance. She signed his name on the insurance. She asked Carmen for something stronger after February 14th. And the night started at 9 p.m. She talked about Moscow Mule and lemon shot or whatever, and, got the fentanyl, and Eric died of a fentanyl overdose.
You're redoing the prosecution. You're redoing the prosecution's closing.
I'm trying to go through in my mind how they would answer that question. They would have to believe all of those steps and the way the evidence is set forth. And if they do, then that's how they would answer your question as far as Eric walking in and saying, I accidentally took him. They'd be like, no, but that's where you get into the possible doubt versus reasonable doubt. Because, Eric could come down and say, I drank a drink earlier in the day that could have had fentanyl in it because I bought it from some guy off the streets. Okay, that's a possible doubt, but is that a reasonable doubt? So you also have to go through that analysis as well, because it's not going to be beyond all possible doubt. It's not going to be with 100% certainty. So I really think it just comes down to how they viewed the evidence, and the credibility of the evidence, especially with Carmen and Robbie.
Well, I think that when it jump ahead
Well, I
to
don't want to get to
the
the closing yet, so
jurors,
we can get to
right.
let's go to the fact that it was only a 3-hour deliberation. What were your thoughts on that?
Okay, really short. I was really, really surprised that they would take that little amount of time knowing a person's life was in their hands. So I was very surprised that they did not at least roll over to 2 days. I mean, it's a 3-week trial. You think they would say, you know what, we got to take more time on this. I mean, there's a lot of stuff here, and they spent a lot of time and money. We really have to take some time. They didn't feel that way at all. 3 hours is lightning speed for a jury, especially on an M charge.
Yeah, I agree that it's fast. Do you think that it automatically means they did not deliberate properly?
No, I don't think that. I think that I think they just had their mind made up.
They were convinced. I mean, that's the point. They were convinced, and sometimes that happens in trials, and sometimes, but it's not like they didn't talk, right? Because I heard some people talking about the fact that like there's no way they could have ever deliberated if it was only 3 hours. We have seen 15-minute verdicts. I think I just heard one of my buddies got an 8-minute verdict the other day. Like
we've had 5. I've had verdicts where the jury, one time the jury walked out of the courtroom, did not make it to the jury deliberation room. They're in the hallway walking, and they all said to themselves, does anybody think they're guilty? And nobody said. They just turned around before they even got to the jury room and came back into the courtroom and said they had a verdict. So that was like a 1-minute verdict, which, obviously is a record for me. I'll never forget it, but 1 minute.
I've never had one like that. Most of the civil cases, like we did have a multi-million-dollar verdict recently with like a 2-hour deliberation. So it's like when you've got to add up 7 figures of dollars and past and future medical bills, and you do that in 2 hours, like to me, that can be more difficult than filling out the paperwork in a case like this. So I think 3 hours, was it quick? Were they convinced? Were they sure? Which frankly, that's how you want them to be. You want a jury to be sure of their verdict, especially if they're going to convict somebody. This jury seemed very sure of this verdict, and that's what goes to the 3 hours. I don't think it, and I'll just tell you, and and you can talk about this more than I can. You've done more criminal appeals. That is not a argument for appeal that you automatically did not deliberate for long enough, because you've made those types of arguments before, and it's not a winning argument.
Yeah, it's a total loser. Yeah, because the presumption of a jury verdict is it's correct.
Right.
And if you don't presume jury verdicts are correct, then you're going to have a real problem in our system.
And it really shouldn't be. You should prove that they're correct, or you should assume that they're correct, or presume. Sorry. Another important thing I wanted to ask you was the change of venue. So they asked for a change of venue. People think it's going to be a part of the appeal potentially. This jury verdict comes back pretty quick. Maybe they knew about the case, maybe they didn't, whatever. Do you think that's going to be something that's going to be in the argument for change of venue, that this jury must have known about the case in a different venue? We would have got more of a fair shake where the jury took it more seriously, took more time with it. Is that going to be part of the appellate argument, do you think?
Not a successful one.
Right.
They may try to make it, but no success. They got a jury, and the jury deliberated and came to a verdict. No chance.
And we didn't see the jury selection, so it's possible that they asked for more challenges. They wanted to strike some of the jurors that ended up getting on the jury, and they did everything right. We don't really know that. I'm assuming with these lawyers, they really did a lot to protect the record. So if there were venue issues, I would assume that they did everything to protect the record.
Yeah, I think so.
Okay, let's get to the closing arguments now. Let's start with the state. Tell me your thoughts.
Overall thought, it was an excellent closing argument.
Okay.
I've got to say he did a fabulous job. Tremendous preparation. The audio visual was excellent. I don't think this is a very large office, from what I understand. That it's not large departments, so they spent a lot of money, and they had to go out and get private contractors, I'm sure, to do their audio visual stuff. But it was an excellent audio visual presentation. He did a tremendous job of going through. I think he did a great job of telling the story. He did a great job of keeping a consistent theme throughout his closing. That is, comes from nothing and wants to be something, even though it's a phony something. She wanted to be something, and this is, how she created her facade and how she had to, keep that facade going, and that, she wasn't good at it, but she sure tried to make other people think she was good at it. So that was a great, humble beginnings kind of thing at the beginning. They did just an excellent job. His demeanor was good. He spoke clearly, And another thing he did that, you know, people sometimes ignore is he spoke with authority. That when he said something, it was believable that it was true. Even though he would say things like, you know, only stick to the evidence. That's why we've got these, you know, visual aids or what, because we're going to show you the evidence, not, you know, the lawyer's opinions, which is not evidence, but the evidence.
And the citations,
which honestly,
specifically the citations.
but you know, it really wasn't true. He showed the citations, and then he would give his opinion about each one of them,
right.
and what they meant. So he didn't just, you know, he would say something, and it could be interpreted two ways, but he would tell you, this is the way to do it. And because of that, again, authority. We said it in the opening. He didn't make things sound like it was possible. He made things sound like they were fact. And that's the way he did in his closing. So he did an excellent closing. He did a great job of putting the transcript testimony side by side. He also did a pretty good job of ignoring some of the problems in his case. For instance, Robbie, as an example, he ignored Robbie's testimony by putting on Robbie's audio.
Right, which was an evidence.
Which was in evidence. And of course, it's better because the jury would have to have remembered Robbie's testimony, but they actually saw the video testimony during the closing. So, you know, that was a really good technique. And I remember earlier we talked about the fact that they had text messages and things, but they weren't reading them to the jury, but they were just putting them in evidence. Well, he had all those text messages up there to actually show them and read them, and he had them highlighted. He did just a tremendous job of presenting that. Let's see what. And I think again, to me. And I think it's going to be borne out. The real key piece of evidence that I really thought was key was the number of cell phone hits. They didn't know what was said, maybe on the cell phones, but they knew how many times they had hits at particular locations. And there were a lot. So extraordinary number of communications at particular locations. And I think that was really important because I think Carmen was not credible. I don't think they would have convicted just on Carmen if that's all they had. I think that the prosecutor did a good job of showing they had more than just Carmen to show that she committed this, and the cell phone records were some of that. And again, we can go through the whole thing, which I don't think we need to do. He also did a good job of showing conflicts between journal entries, times, interesting, point, again, his interpretation, but it took her 6 minutes to start CPR. I think that was a good argument. You talked about it, but the 9:15 p.m. is where she started with the drink, when she started telling her story about what happened that night. That was a good argument. He also showed that she would say she screamed, but on the 911 calls, there was no screaming. He had a lot of things to paint her bad, as a bad person, as a liar, and as a person you couldn't trust. And so, again, that was the key. I think we said that at the beginning. The person was, the key to their prosecution is she is so bad that she did commit this M. And, that's what it was. The fact that she had again, we don't need to go through all the testimony, but it just showed that over and over again, they were able to make comparisons and put the visual aids up that were really good, well organized. Another thing he did, which I thought was good, he didn't read a lot of notes. He looked at the screens, and he knew what he wanted to say based on the visual aid. He would point to whoever was doing them. They would put up the next visual aid, and he went right to it and right to the heart. There wasn't a lot of pauses, and there wasn't a lot of the fact, he had to really think what he was going to say. The other thing is, and again, we talked about this, I think he had built up credibility with the jury. I think that was really important. I think the jury believed it when he said it. And so that's an intangible that you really have to look at. But I mean, I'm a person, I looked at him, and I'm skeptical of prosecutors. I'm sure everybody would know that. To me, if I was looking at him, he to me looked credible and believable when he gave his closing argument.
So I think one of the things that can't be understated is his demonstrative aids. Like you said, they were his outline, which helps a ton, but also it helps things stick in the jury's mind. And he had some very memorable ones, like whatever that animal was pooping against the wall and like the outline of the person. And he's like, we know what happened here, so it's like things like that the jury is going to remember, maybe even some that were funny, even then not a funny moment, but whatever it may be, something that the jury is going to remember. We've used the Spider-Man meme where everybody's pointing to each other, meaning it's the same thing. There are really ways that you can connect with jurors without using your words for jurors that learn differently. And his was just so much better than the prosecutors on the way that he presented it to the jury.
Better than the defense.
Yeah, that's what I meant. Better than the defense. Sorry. But one thing that I felt during his closing argument was that it was so long. Did you think that it felt long, or did you feel like it felt like the right amount of time to make the arguments he needed to make?
I was not bothered by the length. I never.
Obviously, he won. It worked. Everybody on hindsight can be like, "Wow, his closing was so amazing. What a great job. He convicted everybody." Fine. I'm just saying, like, as far as like a lawyer, if you're putting together a closing, did that feel long to you based on how long the trial was?
It did not, because again, I listened to it via YouTube, and it did not appear too long to me. I found that he did a really good job, and when we get to, I want to talk about how he ended the first part of his closing, because I thought that was also very important.
Yeah,
okay,
go ahead.
How he ended it. He ended it by ripping the defense lawyer's opening statement apart and talking about, you saw Noah, they said the evidence will show this. They say the evidence will show that. Did you see any evidence that showed that? There was no evidence that showed that. He went through it over and over again. And that is a huge mistake by the defense. I blame the defense for that. They should not have given an opening. If they were not 100% positive that they were going to do this, or this, they should not have mentioned it in their opening. They didn't need to. They should have only done the stuff they were sure of. The fact that they took a chance like that without being 100% sure of what they were going to do, huge mistake, and he made them pay for it. I think it was an excellent.
Without burden shifting, because you have to be very careful not to burden shift, but you're allowed to. And we talked about it in the Walsh case, and those prosecutors did not do it enough, in our opinion, based on what the Walsh attorney said and did, and their theories. They were just like, we'll stay away from it. But this prosecutor, I think, did it more appropriately, number one. Number two, it wasn't just in their opening, but in hindsight, as I'm thinking back on the trial, there were so many times, and I believe a lot of them were in front of the jury. I know some of them were outside the presence of the jury, but a lot of them in the jury, they would say stuff like, we'll recall that witness, or we'll call an expert to talk about that, or, we'll wait till we bring you back up on the stand then to talk about that, because they were trying to do their directs within the cross-examination, which, looking back on it now, does look kind of shady if you were trying to squeeze it in there without having a case in chief. Maybe that's looked at as inappropriate, but there is some case law that if they would have been allowed to do that throughout the case, that, the prosecution would be able to have a rebuttal case, but they could have done that within their case. The judge could have allowed it. So there's all sorts of legal mechanics and gymnastics that can happen there. But I think they made comments in front of the jury as well that made the jury think they were going to bring evidence. And then when you don't put that evidence up, like, jurors are not breaking this down like a law school class where, they have no burden of proof, whatever. They're thinking, these people told me they were going to prove something to me. They didn't. So what am I doing? Because, what they said didn't happen. How they said it, that's not how it came out. And it just creates issues.
Yeah. See, and that's different than the burden of proof.
Right.
Because when you think about it, the jurors are going to say, the jurors are going to say, well, I know that they don't have the burden of proof, but they did say they were going to do this and they didn't. So again, you're right. So it just hurt their credibility. They just kept their mouth shut. And that's what I'm saying. I blame the defense for leaving themselves open to the way that he closed the first part of his closing statement.
And the defense said during theirs, he said that, we didn't do X, Y, and Z, and strategies changed during trial. That's the only comeback she had. And I was like, I was like,
my head, I almost exploded. I almost exploded when she said that, because the juries don't know strategies. what do you think came to their mind? What thing came to their mind? Isn't your strategy to prove her, to make her innocent? Isn't your strategy for a not guilty verdict? I mean, what changed here?
I actually think strategy can be a negative buzzword. Like, oh, you're trying to trick us with your strategy and your, twisting of things like lawyers do. I think strategy could have been a negative buzzword for this jury. So what did you think about the defense's closing?
I hate to kind of say this because I do hate saying things like this, but she did not have credibility with the jury. So when she said things, it wasn't necessarily that the jury believed it. When she interpreted evidence the way she thinks it should be interpreted, it was so blasé that it didn't have a lot of passion. The prosecutor was far more passionate and strong. I think she was weak in her closing and in her presentation. She said some things that were reasonably good. She tried to explain some things that were reasonably good. I don't.
She explained the walk the dog letter exactly like you said.
Yeah,
the walk the dog letter could absolutely be true. Why didn't they investigate this? Why didn't they investigate that? She hammered O'Driscoll just like you said. I thought there were some good points made, and I think it's easy to look back now and be like, oh, she sucked. But I thought she made some good points as far as the walk the dog letter and O'Driscoll. If you agree with it, I completely disagree with her view of the walk the dog letter. I agree with her view of O'Driscoll. I think he was horrible. I think he did not do a good investigation. At least he didn't explain it well on the stand. And I think the way that they pushed Carmen and how she had, maybe he got the dog pulled out with somebody else. I think there were some good points, but I do agree with you that she lacked credibility. And the walk the dog letter to me was just such an implausible argument that you made last week and she made during closing. I was just like, there's no way that it's true. Like this is not how somebody writes a true statement in a true story. It's just not. I do agree. I think the better argument is, which jurors aren't going to believe this, but innocent people lie too. Innocent people will ask witnesses to lie for them too. I think that's more true than what's in the walk the dog letter is true. That to me is like, poop. I don't believe anything else you said. That's kind of my feel.
She also, she explained the deleted messages as, she didn't want people to know about her affair or drug use or those kind of things. She had some explanations, but you know what? As far as I'm saying, you forgot her explanation as soon as she finished talking. She didn't hammer it. She didn't hammer Carmen like she said the right things about Carmen, but she didn't hammer Carmen like she should have hammered it. And she certainly didn't hammer the prosecutors, because another thing that I thought that she did, and this is a common mistake for lawyers, she prepared her closing not caring what the prosecutor said. It was obvious that she prepared this closing and she was going to say it just like she prepared it the night before, and she made no adjustments for the things the prosecutor said in their closing. And that's why, when and sometimes you've questioned me about this, is that when I do that, I don't write out word for word my closings. And I do it by
my closings word for word. I don't know anybody that writes out their word for word closings.
And I do it by bullet points to make sure that I cover certain topics. She had this all written out, you could just tell, and she did not adjust, and she should have, for some of the good arguments that the prosecutor presented in his closing. And she should have addressed those better than she did, other than just what she had prepared the night before. So I fault her for not being pliable and not being able to adjust her closing to attack the prosecution. And she didn't attack them. The prosecutor attacked them like crazy, was all over the way that they presented their case, or they did their cross-examination, or how they did their opening statement. She should have attacked that prosecutor, but she just let him alone and just said the words she wanted to say on her page, and that was it, with very little really passion.
Yeah,
that's really where I fall.
And you can do both, right? You can have your prepared closing, but you also have to have a response to what the prosecutor said. And he did finish, or she did try to deal with some of the prosecution's case, but not as much respond to the closing argument. And I just think she was not as good of a presenter or orator as the prosecutor was. That always makes it difficult. She stayed right behind the podium the whole time. What I get onto you more is I literally don't care about writing out a closing. I would never recommend writing a closing. Is when you're cross-examining a witness and you have sticky notes on every single page of a binder. And so we're sitting here flipping back and forth, the binder's breaking and papers are falling. I'm just like, oh, that's what gives me the sweats sitting over at council table, not closing. Never worried about closing.
I'm doing one right now.
Yeah.
With a huge binder, the case.
Yeah.
And I've got the huge binder. In fact, the last couple of days I've been putting sticky notes all over the binder.
Yeah. I would have page and line numbers and PDFs set up and pull up the first PDF, exhibit 1, 2, 3, just, different ways. There's multiple ways to skin a cat, they say. So overall, I thought that her closing argument it did make me, you said she had no passion. I think she believed Kouri was innocent, at least in how she was arguing it, kind of how you say you believe your argument by the end of every case. I do think she believed that. It's always interesting to me, and you can tell me your thoughts, how it feels to make a closing argument that you absolutely believe. I think she did show some passion, so I'll disagree with you a little bit there. I think she did show some passion. So you absolutely believe this argument. You give this argument, and 2.5 hours later, the jury comes and kicks you in the teeth and is like, guilty. We don't believe anything you say. We don't find you credible at all. That's happened to all of us. We make this closing argument, especially as criminal defense lawyers, and you go and lose and your client's guilty. What is that feeling like?
Well, I don't want to say you shake it off, but you've got to, you got to trust the jury system. Even though I know I've said that I disagree with what the jury did in this case, I still believe in the jury system. And the toughest part really isn't the fact that you lost. The toughest part is that you have a client that you have to talk to after that loss, that may be going to prison for a very long time. And you've got to try to explain to them that there is still hope, that there are appeals, and that you are still out there fighting for him, and that there still may be some future justice here. Mm-hmm. That's the toughest part, is the conversation with the client after the jury comes back. Me personally, my ego isn't such that if I lose a case, it hurts my ego. I feel more for the client than I do for myself.
Yeah. I think that it is. You have to realize it's part of the job. It is not. Sometimes it's a reflection of your ability as a lawyer. Usually not. Usually it's the facts of the case, the evidence of the case. That's what happens. And so that's what you have to tell yourself, and that's what gets you getting up and continuing to fight for people's rights. Because if every time you lost, you're like, okay, I'm done with this, I don't want to do this anymore, then you're not made to be a criminal defense lawyer. That's for sure. So when we talk about 3 hours, obviously it was a pretty quick verdict. Some of the jurors, maybe just one juror has come out. Oh, go ahead.
Because I'm thinking, can we talk about the rebuttal?
Oh, yeah. We didn't talk about that yet.
Yeah,
go for it.
Because he did a tremendous rebuttal, and again, it was the hey, we look at the evidence. Lawyers. I'm not going to give you my look at the. But that's all he did in his rebuttal.
Right after he said that, then he tells him what he believes the walk the dog letter actually meant.
Right, and in fact, he looked at the walk the dog letter. And he read the walk the dog letter the way he thinks the letter meant, which I thought was great. I got to tell you, I thought he did a tremendous job by interpreting the walk the dog letter. That was a great way to close it. And the other thing, and I don't know, again, was not addressed by the defense, was the 3 times at the gas station. I thought that 3 times at the gas station was a pretty good piece of evidence, and he saved it for a rebuttal.
You mean that they had another deal after Eric died?
No, they actually showed where they went to the gas station every time they did the drug deal. The only time that Carmen had ever been at that gas station was the times when they did the drug deals.
Right. What are you saying is important that he stuck out? They mentioned that, I thought, in both closings, didn't they? I don't think she mentioned it. I know it was mentioned in opening by them as well.
Yeah, I don't think the defense mentioned that. Okay. But then the fact that she was, the autopsy. They talked about the phone call, how she would feign ignorance. He went through all that in his rebuttal. That she would be fishing for information, even though she knew the end. It was her prescription. So how did she not know what it was when they were talking to the medical examiner's office? and she's not a very good writer. And that was kind of an interesting comment by him. And then how she would trade on death and her children, the death of her husband and her children. She traded on that with the book, and there was no other rational explanation. That's the way he ended it. So I think he did a tremendous close. And like I said, the walk the dog thing was classic. I mean, there really is. What he did on that was really excellent.
Yeah, and so like I said, one juror has come out and spoken, and a lot of it had to do with his rebuttal. So she was basically saying that everybody had a different kind of smoking gun. Some people thought it was the walk the dog letter. Some people thought the walk the dog letter wasn't the most significant thing. They were all kind of appalled when they heard she wrote the children's book, which, makes you think that they thought you're only appalled if you think she did it, right? Like, so they all thought she did it. Then when they heard she wrote the children's book, the way that the state laid out the evidence in the case, basically proving that she did it to this jury, and then showing her how despicable she was after the fact. That's basically what they showed her in the timing of the children's book and the walk the dog letter. So it worked perfectly for the state because they convinced the jury. And that's the point of a trial. The state has to convince the jury. They have to force the jury into the guilty pool. So did you look at any of the comments by the jurors? Have any thoughts on that?
Yes, I do. I thought it was interesting that some people, by the way, I know you talked about the walk the dog letter and how you think it can only be read one way. There were jurors that did not believe it could be read only one way. And they did not assign significance to the walk the dog letter.
That's different.
Right.
Okay.
Well, it's if you read it the way the prosecution said, it's phenomenally significant.
Well,
I mean, come on, how can it not be significant if
because like
you
I said,
believe the
innocent
prosecutor?
people lie too. Innocent people want people to lie for them so they don't go to prison as well.
Yeah. She felt the cell phone pings, the cell phone data was really important. Because she also said they really didn't think Carmen was very credible, or Robbie.
On their own, maybe, without the corroboration, but that helped them kind of secure it all together.
Right. But they said on their own, they didn't think they were very credible. But when you look at the cell phone pings, that made him credible. The other thing that's important about what she said, I mean, it's not going to come up in the appeal because it's not part of the record. But when you asked the question earlier about change of venue, how interesting was it to you, it was to me, that this jury did not know about the book?
Well, yeah,
because you would think that anybody who had any knowledge about this trial beforehand would know she wrote the book, because that was a big part of why this trial was so newsworthy.
Wasn't that like the title of or the slogan of it, like children's book author murder case or something? I think that was part of the title for this entire trial.
Yeah.
So that was good.
But so I mean, really surprising that these people, they said it was like a gut punch. I forget the word she used, but it was a significant feeling that they got by the fact that she wrote this book. So again, looking at this, obviously they thought she was a bad person. Oh, another thing she said that I thought was interesting. If you believe it, or maybe she's trying to minimize it, but she said at the very beginning of the trial, they were feeling sorry for her, that they felt that she was there all alone and this big wealthy family was ganging up on her. And so they had sympathy for her at the beginning of the trial. And so, that's something that's really important that I think that the defense might have played a little more on is, her, being all alone, in this big cruel world, and everybody was picking on her. Although they did say that she was the only suspect, but.
Well, they definitely were talking about the money and the sisters and the private investigator and the accountant all paid for by them and the brother-in-law. They definitely tried to build that narrative. I think it partially worked, obviously not enough, but partially worked.
Yeah. So, I thought it was, interesting. I only saw a snippet. So I have not seen the entire interview. I don't know if it was longer than the 3 or 4 minutes that I saw.
Yeah, that's all I've seen so far as well.
Yeah. So that was it. So, what can I say? Hey, you win some, you lose some. If I was a defense lawyer, I would have done what they did. I would not have put a case on. I would have thought that we were better off not putting a case on. I would have thought we were better off not putting the defendant on and relying on the closing argument. But I also would have, in my opening statement, prepared for the fact that I would not put on a case and not put the defendant on, and so I would not have hamstrung myself into a particular situation. I would have left my options open.
Yeah, I think I would have put on a case in chief, if only to put on some experts to talk about the drugs and how they could look the same and how people died accidentally of fentanyl and people thought they were getting oxy and it was actually fentanyl, or how pills can be laced with fentanyl. I think I would have developed that a little bit more. And then, I definitely would never have put Kouri on. Like that was,
What
go ahead.
what about the brother? The one she wrote the dog letter to.
I think that could have gone either way.
It seems, and I know it seems kind of strange they didn't, that he was not ever thought about as a witness or anything. In their opening, they didn't say he was going to testify. Or
we don't know that he was never thought about, but I think that, obviously he could have been good, but he could have been really, 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 really bad as well. And they had tons of recorded phone calls with him. So I think if he would have testified, those jail calls would have come out even more, and potentially he would have been caught in lies and impeached and, look like he's trying to lie for Kouri. And, he would have had to answer for the walk the dog letter. Is this actually true? Why didn't you produce these text messages? Did Eric actually say this to you? Why would Kouri have had to remind you of that? There was a lot of fodder for him. And the mom, there's stuff going on with the mom, I guess too. People are asking because there was a lawyer appointed for her within this case. I don't know, so I'm not going to speculate about what that means, but, so, I think there was potentially a lot of reasons why they didn't call her mom or her brother, but those would have been the most obvious witnesses to choose during the defense's case in chief.
Let me ask you too, because you obviously know more about this case than I do. Some of the things they said in the defense opening statement that the prosecutor said, did you see any evidence of that? Did they have a wiretap on her phone for a year, or were they recording her conversation on Kouri's phone? Were they recording her conversations?
I think they were the jail calls. I think it was the jail calls.
Oh,
yeah, that's what I picked up from that. I think there was a lot of jail calls. I didn't listen to all of them, but I think there was a lot of jail calls.
so you think they were referring to the jail calls?
I think so. I can't remember what you're specifically talking about. I mean, obviously there was a phone call
the
that
prosecutor said, go ahead.
There was a phone call that Kouri's friend recorded as well. So there may have been recorded phone calls that were self-serving by Kouri and her friends as well, because we listened to one of those with Bryce and Chelsea, Kouri's friend, that Chelsea recorded. So there was more than just the jail calls, but I think the majority of the recorded phone calls were jail calls. But I'm not sure. They could have bugged their phone. I don't know. I don't know the answer to that.
Okay. I don't either, but it was an interesting comment by the prosecutor that the defense said in their opening. And again, I would have thought we would have heard something about that during the trial. So,
yeah. So, any other thoughts about the jurors, about the verdict, about how the case ended? Any reason you think she's not going to get the max sentence, the life without parole?
No, I don't. One thing that I think that I would like to mention, though, is the motion for mistrial.
Okay. After the closing, the first close of the prosecution. Right.
They did this motion for mistrial, and during the prosecution's case, I don't know if it was real quick, and you had to listen to it really close. The defense objected to something, and when they stood up to object, the judge said, "Please be seated." So the judge clearly gave a signal that he didn't want any interruptions during these closing statements, and that you save everything, for the end, or save everything during a break. A lot of times, you'll interrupt at the time because some courts say you should make your objection right when the violation occurred. But this judge obviously clearly sent a signal that this wasn't going to happen in his courtroom, that you weren't going to interrupt somebody during their closing. So I thought that was interesting. The Black Widow, narcissist, and demeanor at counsel table. One of the things that the juror talked about was the demeanor at counsel table, that the jurors talked about how she was kind of unemotional, or, didn't show a lot of emotion at counsel table. So obviously they did take into account, whether they'll admit it or not, what her demeanor was at counsel table, which was specifically mentioned and improperly mentioned by the prosecutor during his closing argument. I think that's going to be a real good appellate argument. We talked about things that, dead bang losers. This is not a dead bang loser. this one's got a chance.
Yeah, why do you think he did that? I mean, obviously her demeanor was bad and questionable throughout the whole trial, but that's not evidence. That's not an appropriate argument. He's a seasoned prosecutor. He still decides to make that argument. And then now the reason it might not be a great appellate argument is because the judge did do a curative instruction, but even the judge's curative instruction to me was encouraging the jury to consider her facial expressions and demeanor during the trial. And I don't even know that that's appropriate. Because they're supposed to make their decision based on the evidence presented to them, and that's not evidence presented to them. So I do think that that's going to muck it up a little bit. I don't think it's going to be enough to win the argument, but especially if the jurors are coming out saying that had an effect on them, I just thought that was a real unforced error by him.
Mm-hmm. I agree. And so I wanted to mention that because I thought that was
what did you think about the Black Widow comment and the narcissist comment? Fair argument.
Well, you've seen me make closing arguments.
It's fair argument, I think.
Yeah. I mean, Black Widow's kind of a minor.
Right. Saying somebody's a narcissist is like, I wasn't saying the official, that she had official diagnosis. I'm saying she was a narcissist. Right. Everybody has like an idea of what a narcissist means. I thought that was totally appropriate argument.
Yeah, I did too.
Okay.
Yeah, the only good one was that. Their demeanor at counsel table. Yeah. And the fact that the juror actually mentioned it during their interview, I thought was interesting. Again, that's not going to be part of the record on appeal, but that's interesting.
Yeah, that'll be interesting.
Yeah.
Anything else? Any other final thoughts before we go on Kouri Richins?
Well, I thought it was an interesting case because it's a classic case of circumstantial evidence. It is an extreme case of circumstantial evidence. And I think that people can see how you can get convicted based on this kind of evidence, even though there's no eyewitness and no actual proof that you actually administered the fentanyl or how you administered the fentanyl, the manner in which it was administered, you can still be convicted of them.
Yeah, I did like the way the judge answered the directed verdict argument that as long as Kouri intended to poison him and did poison him, she didn't have to specifically ask for fentanyl. It didn't have to be fentanyl. She didn't have to know it was fentanyl. She just had to have the intent to poison him and then successfully poison him, and she had to be the one to poison him. I did like that explanation and thought that was very fair. And how a reasonable juror could get to guilty on this case. And I agreed with that. I agreed with the judge's summation there. Okay, well, that's all we got. Those are my dad's thoughts on the verdicts and the closing arguments. If you guys have any more questions, throw them in the comments and we can get it back on to answer them. Dad, thanks for joining me along for another ride through another trial. But that's all we got. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.